Hello, my name is Terry Gorry and I'm a solicitor in Enfield. I do quite a bit of employment law. A lot of employers have got into financial difficulty in the last number of years, and I've had quite a few employees come to me with difficulties in relation to getting paid for back pay, holiday pay, pay in notice or in lieu of notice, and so on. This short video will explain to you what the options are in terms of or when an employer basically goes wallop. So an employer's insolvency does cause great problems for employees, especially in relation to arrears of pay, holiday pay, sick pay and notice entitlements. The insolvency can fall into one of a number of categories. For example, has a receiver, liquidator or examiner been appointed? The appointment of an examiner or a receiver does not immediately terminate the employment relationship. The appointment of an official or provisional liquidator may lead to termination, but not in all circumstances. So how are employees protected if an employer goes belly up? Who pays arrears and wages and holiday pay, other pay related entitlements? Well, there's an act from 1984 called the Protection of Employers Insolvency Act 1984. It provides that employees may claim for arrears in pay, holiday pay, pay in lieu, statutory notice entitlements and certain other employment related pay entitlements from an insolvency payment scheme. This scheme covers also awards made to employees for unfair dismissal, minimum wage, working time, discrimination and certain unpaid pension and PRSA contributions. These claims are generally made through the receiver or liquidator who has been appointed to the company. Depending on the circumstances, he or she then processes them through the insolvency payment section of the Department of Social Protection. A redundancy situation is slightly different insofar as if an employer is unable to pay redundancy, then there's a separate redundancy payment scheme which will pay out. This is a different scheme from the insolvency payment scheme, even though both are funded from the Social Insurance Fund. So your redundancy payment scheme and you have the insolvency payment scheme. The insolvency payment scheme then covers employers who are in one of four broad categories. They're bankrupt, they're liquidated, they're in receivership, or there is a deceased insolvent employer. However, an employer that ceases trading but doesn't go into official liquidation is not covered. The employer must become insolvent within the terms of the Act, in other words, within the definition of insolvency in the Act. Payments made under the scheme then, there are limits in respect of payments for sick pay, holiday pay, pay in lieu of statutory notices and arrears of pay. The maximum weekly rate is €600 per week, with a maximum of payment of 8 weeks. Generally the scheme only covers entitlements arising in the 18 months prior to insolvency or termination of employment. The payments are taxable with PAYE and PRSI being deducted by the receiver or liquidator. If a claim is disallowed, the employee may make a claim to the Employment Appeals Tribunal. This appeal then is supposed to be made within 6 weeks of the adverse decision, although the EAT can extend this time period at its discretion. A payment made to an employee under the insolvency payments scheme does not prevent an employee from making a claim to the redundancy payment scheme. My name is Terry Gorry. I'm a solicitor in Enfield in County Meath. My website is employmentrightsireland.com. Thanks for watching.